pushed the complainant to the ground, causing her to scrape her right arm. While the complainant was still on the floor, the defendant stepped on her neck. Officer noted—
Stepped on her neck.
I want the truth. You can't handle the truth.
Good morning, Mr. Venable.
Yes, sir.
Mr. Venable, you're charged with 2 counts of assault. One is of a family member. On both of those, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have, okay, Ms.
On January 21st of 2024 in Harris County, Texas, officers were dispatched to an AFM call. Officer met with the complainant. The complainant and the defendant have been dating for 5 months. The complainant and the defendant were arguing. The defendant pushed the complainant to the ground, causing her to scrape her right arm. While the complainant was still on the floor, the defendant stepped on her neck. Officer noted—
Stepped on her neck.
Yes, Judge. Officer noted redness on the complainant's arm and neck.
You know if it impeded breathing?
No, Judge. I don't, I can't, let me check. It wasn't charged as an impeding breath, so.
Well, I know it wasn't charged, but is it?
I would say yes, as the only reason you would step on someone's neck would be to impede breathing. I would ask this clown what was the purpose of doing so. But chances are, with weak males like this,
The
they
DIMS
lie.
don't say that she had any trouble breathing, but I'll look at the offense report, Judge.
And here's the other thing. The first assault is from October of 23. The second assault is from January of this year.
Yes,
And now we have a felony evading arrest on December 10th.
yes, Judge.
Were these 2 Bs? Was he out on bond for these? Vic, do you know?
It looks like. No,
So
it
this is
looks-
Venable, who's now picked up a 3rd case. He had 2 misdemeanors, one's from 23, one's from 24. Did we ever do PC or had he ever been on bond
No, Judge. It was just a non-arrival.
for the whole time? All right.
So now we know that this pathetic-looking thing can't keep his little weak hands to himself.
Judge, it doesn't say that she had trouble breathing. It just says that it caused her pain.
Okay. Can you do probable cause? So that's the family member, right?
That's the AFM.
Okay.
Judge.
Can you do the first case? Because I don't think we've done probable cause on that one now.
Imagine someone in your family doing something like this to your aunt. In my family, I would have to get in quick, as my cousins would want to play with him first.
This is the AFM from January 21st. Oh, the ABI, the one before.
Yeah, the one before.
On 9/29/2023, officers were dispatched. On arrival, officers spoke with the witness, the complainant's wife, who said that the defendant assaulted the complainant by slapping him in the face because the complainant's dog killed the defendant's girlfriend's cat. Then officers spoke with the complainant, who said he had invited the defendant into his residence to discuss the situation when the defendant said she should knock the shit out of him. And the next thing complainant knew, the defendant had struck him across the left side of his face with his hand, causing pain.
Mr. Venable, I want you to understand one thing, that I'm going to do everything in my power to protect my community at all costs.
Sure.
And if that means I have to make your bond extremely high, taking you into custody, kicking and screaming, I'll do it in a heartbeat. Do you understand?
Sure.
I'm ordering you as a condition. I'm going to find probable cause on both of your cases, and I'm ordering you not to have any contact with either of the people in this case.
Sure.
There's a protective order that has been issued in the family case. I would get to know it. Don't say anything. You will get the opportunity. Now is not that time. I'm telling you what the expectation is while these cases are open, and what the expectation is for you to be able to live in this free world. Because if you don't abide by these expectations, I'm going to take the free world away from you. You are not to consume alcohol or illegal drugs, and I'm going to randomly test you. You're also not to have contact with either of these people, not to be in possession of any weapons, and abide by the conditions of the protective order. If you violate those conditions of the protective order, the state can file a 4th case, a violation of a protective order. If they do, that is the capital murder of misdemeanors. It's one of the worst cases you can pick up, and you violate those conditions, I can have a hearing to hold you at 0 bond. 0 bond, and I'll do it in a heartbeat to protect every person Do you understand? Do you have a Texas driver license?
I do, but it's,
So you do not have a Texas driver license. I am now ordering you also as a condition of your bond not to drive. You will be signing an affidavit with me today promising you that you're not going to drive. I don't care what's going on in your life. I don't care what you got to do. I don't care where you got to go. You violate this, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car.
an Ubering to and from, so.
Don't. There's nothing you can say to justify. I'm not asking you. I'm telling you what the expectation is.
Yes, Your Honor.
We are now going to reset your case to give you time to hire a lawyer. So, Rosette, the order in the one that's signed by the magistrate is allowing contact, but I'm going to issue one now so that he cannot have contact. Okay? Just so that you know.
But also, I don't see a motive on the assault violence injury case.
Well, it's because it's not a family member case. That's why. You can only do it on the family member cases. All right? That way. John D.
Proceed.
Thank you, Your Honor. As the court can see, Mr. De La Rosa is an amputee, in which he suffered from injury a few years ago. Your Honor, we're requesting if the court would consider probation. I believe that Mr. De La Rosa would benefit from being on a mental health caseload as well. He does suffer from some mental issues that I feel that would be beneficial if he could receive care through either MHMR or Spindletop. He understands that he does have prior convictions, so as a convicted felon, so he cannot possess a firearm. And he understands that moving forward, no matter what situation he's in, he cannot have a firearm. Your Honor, he does have 2 children that he would like to be better involved in their lives. One of the main issues that I see in the PSI is education. He has a 6th grade education.
To those viewers and my subscribers that are here at this time, can someone please tell me what age would you be if you were in the 6th grade, please?
I think it would also benefit if he would be allowed and participate in the GED program through the probation department as well to help him to develop some skills.
Here, let me speed up this slow death. The lawyer says he could benefit from drug rehab, and he promises he won't be a piece of shit anymore.
And so we are requesting probation.
Thank you, ma'am. Mr. Nichols?
Your Honor, he has 3 prior felony convictions, one for being a felon in possession of a firearm, one for aggravated assault with deadly weapon. He should have been habitual. I took into consideration his health issues when I made the offer of an 8-year cap. I don't know that he deserves any more consideration for what has happened to him. You see his gang history, his criminal history. I think 8 years is appropriate in this case.
And I'm sorry.
Mr. De La Rosa, you wanted to say something?
Yeah, let's get a close-up of this guy's head.
I do got priors now, but I don't know like juvenile stuff like that.
So in 2015, you were not a juvenile.
2015, that was when that conviction was like I think 7 years.
That was your conviction for unlawful possession of a firearm by a felon. And you got a 2-year sentence.
Yeah, no, but I did my time and I did parole. I did good behavior.
Right. So you should have learned. Not that you can't possess a firearm. I mean, and Ms. Holmes is doing the best she can, saying that, you know, you understand and that you can't possess a firearm, but you've already gone to prison for that. So
I was at the wrong place, wrong time. Now, I mean, it wasn't my possession due to the fact that I am a felon. I'm not denying it.
Wrong place, wrong time. So somebody pushed him into a bunch of gang members and he couldn't find anyone to push him away.
But, you know what I'm saying? I would deserve, I feel like a second chance or something.
well,
I always keep like, I don't want to get thrown in prison, come out when I'm 38 or something like that.
well, and I understand. Well, and here's the thing, Mr. De La Rosa, nobody wants to get thrown in prison. And what I do today isn't anything that I'm doing. It's where you've gotten yourself with your history since you've been a juvenile into being an adult, knowing that you cannot possess a firearm. You've got 3 prior felony offenses. One was when you were certified as a juvenile, that first one.
And then if you didn't understand the law about deadly weapons, you should have, or carrying a firearm, you should have back in 2015. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement I followed, so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, we know this now. I'm required by law to read this to you.
Luckily, my guys don't have to listen to this, as they have a me, and me has edited out all the boring stuff.
All right, good luck to you, sir. You can go back with the bailiff.
Here is something for my favorite subscribers of the whole of YouTube, which would be you, my subscribers. The other day I was over at my favorite court channel, Time Served, viewing the most excellent of episodes made by one of my most favorite creators, who goes by the name of Phil. And as I was gorging and feasting watching Phil's court cases, I came across a case which Phil had recently uploaded, which I believe, out of the millions of court cases on YouTube, must be one of the most satisfying rulings I have ever seen. And I am probably like you and have seen a lot of court cases, but this one has possibly the greatest implementation of a ruling made by a presiding judge in a US courtroom that anyone has seen before. If you have not seen this case, it is a must. If you do not know who Phil is or heard of the channel Time Served, then I am thinking you are either North Korean or possibly an alien. So if you are not one of those, then what I have done is placed a link to this amazing episode on Phil's channel, Time Served, at the end of this episode. So please make sure you check that episode out, and make sure, if you haven't already, subscribe to Time Served. It's the court channel which made E.T. say, "Fuck going home. I'm staying with the apes and watching Time Served." It really is that good.